and annul against Chief Minister Anguilla and others.
Now, as you can see, Lord Stevens is joining us remotely.
Thank you, my Lord.
We've only got a day. You can take it we are pretty much immersed in this, and we're familiar with your written cases, and indeed we've discussed the case and we've formed a preliminary view. So you can take. You don't need to repeat what's in your written cases.
My Lord, I'm grateful.
One issue that, just to flag up now with you, Mr. Pisky, is that if we are with you, there's a question in our minds as to how far you will want us to go, whether you're going to invite us simply to say that certain things are arguable or not. For example, as to the power, as to the effect of the regulatory regimes and the powers of a receiver and the powers of the administrator, or whether you want us to go beyond arguability and make decisions as to what the legal situation is.
Yes, my Lord.
That's probably the main point for you that isn't really addressed in your case.
My Lord, I'll reflect on that, and I'm sure my learned friends will probably also have something to say on that as well.
Yes.
It may be that they would say, if it's arguable, we ought to have a chance at least to put in evidence that we didn't yet put in. And so I'll need to think about what my response would be to that in reply, if that is their position. But can I reflect on that and come to it after I've introduced the case?
Yes. I mean their position basically is no decision. There's no question of any decision being an issue here because it's all determined by the legislation.
Well, the third and fourth respondents say that. In my submission, it appears that the first and second respondents' position is rather more subtle, and it rather looks as though they say decisions were made by the third and fourth respondents, or at least decisions were to be made by them. Mm. And I think there's a passage in the skeleton argument of Mr. Knox, KC, which says, and they did, or some words along those lines. And so one of our big complaints is, well, we ought to have been told about those decisions, chapter and verse, at least in terms of when they were made, who made them, and what the key reasons were for those decisions, because it's evidently the case that it is being said to the court that decisions could have been made and were made. But I totally accept that the third and fourth respondents have if you like, what they would call a knockout point, which is that we were never eligible in the first place.
Yeah.
And so if that's the answer, it doesn't matter, they would say.
Yeah, yeah. Well, perhaps I should be quiet and let you...
Not at all, my Lord. It's very helpful, and I will take into account the indications. Could I just introduce my colleagues? Obviously, I appear for the appellants along with Miss Natasha Simonson, Mr. Eduardo Lupi, who was a co-author of our printed case, is sadly unavailable. The first and second respondents are represented by Mr. Peter Knox of King's Counsel and the Honourable Attorney General Mr. Dwight Horsford and Mr. Theon Tross. Those two gentlemen have kindly vacated their seats for the morning and are sitting at the back for reasons of space, but that they will obviously approach in due course. And the third and the fourth respondents are represented by Mr. Paul Dennis of King's Counsel, Miss Nadine White-Lang, and Miss Naveen Fleming. Well, my roadmap, as it were, for this morning was going to be 5 key submissions. One is that the threshold for this case is a low one. We say that the threshold to grant judicial review is low. That's our primary submission, and the points connected with that. The second is that the facts and the procedural history of this matter strongly support the grant of leave. Third, a summary of why we say each of the grounds set out in our judicial review application were arguable, along with a fallback submission about candour. And then fourth, submissions about why the third and fourth respondents are wrong, looking at the relevant legislation to contend that the appellant's deposits were ineligible from protection as a matter of law. They are also wrong, we say, to suggest for the first time in this court that we had an alternative remedy and that leave should or could be refused on that basis. And finally, submissions about why the first and second respondents are wrong to suggest that they have no legal responsibility for the decisions or failures complained of in this case. The first point I'm sure I don't need to dwell on for very long. It is well established that the threshold for judicial review is low. If the applicant shows an arguable ground with a realistic prospect of success, they should ordinarily get leave. If, on the other hand, the legal position is, quote, entirely clear to the court at the leave stage, such that the claim cannot succeed, then leave is usually refused. And we have summarised the principles at paragraph 7 of our case, which is page 1670, or in the key documents bundle behind the third tab. So that's paragraph 7. We've summarised the cases there. I'm not going to take you to all of them. It may be worth noting that the language I've just quoted, realistic prospects of success, entirely clear, and so on, is taken from a judgment of Lord Sales in the Ayers Caesar case. And if you want the reference for that, it's page 2130, paragraph 2, per Lord Sales. That's the first point, and I don't think it can be is likely to be disputed. Secondly, is something that has been a little bit more controversial in the history of this case, and it's a point that I make at the level of principle, which is that the activity of deciding that something is or isn't arguable is the result of a judgment, not a discretion. It is one that needs to be exercised with caution because it is the end of the road for the JR applicant, and it's being exercised before the respondent has provided a full picture of what actually happened. I'm not sure that authority is needed for that proposition, but a very similar point was made in a case called Peerless, Peerless, at paragraph 24 by Sir Paul Girvan, and for your reference, that's page 2268. I recognise that in that case the context was as a discussion about a material non-disclosure by a judicial review applicant, so it's not the same context as this case. But what was said there was, in my submission, very similar to the point I'm making. Of course, I accept that there are potential reasons to refuse judicial review leave which do relate to discretion, such as delay, and relief is also a question of discretion. But it is important to start from the point that the decision about whether something is arguable is a threshold question of judgment. And the reason apologies if I'm labouring it, but as we set out in our case, the Court of Appeal took a quite different approach to how to review the decision of the judge about that, and repeatedly described it as a discretion. The third point is that the courts are or can be swayed towards granting leave where either A, the decision maker has failed to give the applicant a reasoned account of what it has actually done, or B, has failed once proceedings have been commenced to provide a full account of the facts to the applicant and the court at the leave stage. So an example of A is Peerless again, that's paragraphs 27 to 28, page 2270. And for B, there's a recent case, which I'm afraid was not in our printed case, called the Police Superintendents Association judicial review case. It's a decision of the High Court of England and Wales, Mr. Justice Fordham, summarising the candour principle in a manner which I submit is helpful. At paragraph 15, the case starts at page 2734.
This is a rather controversial case which may end up coming before us sitting wearing different hats.
Is that so? Yes, my lord. But I would hope that at least sub-paragraph 15, sub-9 would not be controversial. And if I could just pull that up, it is page 2746, the modern approach set out there, the duty of candour applies prior to and for the court's consideration of whether to grant permission for judicial review, though what is required to discharge the duty at the substantive stage will be more extensive, and the limited nature of disclosed material could inform a decision to grant permission. That's the 9th principle there.
Could you just help me for my note, Mr. Pievsky? You divided your third point into A and B, and I didn't manage to write down A.
So A was the decision itself. If there is no reasoned decision, the court is more likely to grant leave, simply because the facts are unclear, and that's peerless at 27 to 28.
Thank you.
And B is, even if there is a reasoned decision, if there is an absence of whatever of candour at the permission stage, which will obviously be less extensive as an obligation, then that itself can be a reason to grant leave. While we're there, could I ask you to just look at paragraph 10, because it'll be relevant to something I say later, which is just the principle of unpleaded grounds, which Mr. Justice Fordham describes, that it is recognised that candour can require the provision of information which assists the claimant to particularise their judicial review claim in a way that might not otherwise have occurred to them. And that, in a sense, is a logical consequence of the position that one starts with in judicial review, which is the famous famous metaphor that the cards are in the authorities' hands. The claimant often doesn't know what has happened. So that's the first point, the threshold that exists. Second point, the facts and the procedural history of this case. And I'm very grateful to hear that my Lord has read the printed cases, and I don't intend to go through it. Just for your note, again, pages 1672, that is where we start with our factual background, and we go all the way through to 1691, which sets out the facts of the case and the procedural history of the case. And if I could, at the risk of, I'll try not to repeat what's said in there, but we say that 6 key points emerge from this. First was that there was a coordinated policy, jointly and publicly articulated by the government, the ECCB and the receiver, to protect all depositors of the 2 failing banks, referred to as National Bank and Caribbean Bank, and a legislative mechanism to ensure such protection. In particular, as you will have seen, there were going to be depositor protection trusts, DPTs, and they would protect over time the larger depositors of the 2 banks. For the smaller deposits, the receiver was going to be transferring the deposit liabilities to a new bank, NCBA, for immediate access via purchase and assumption transactions upon the approval of the ECCB. And that was under Section 142 of the Banking Act 2015, page 1799 to 1800. And I will come to the legislation in a minute.
With the large depositors, was some of their liability transferred to the new bank and the remainder, or were they left entirely? I thought it was the first 2.8 million that was of the large deposits that was transferred over to new bank.
Yes, and that's my understanding, that the first $2.8 million is to go to NCBA, and anything over that threshold is going to go into the DPTs. Apologies, that's my understanding.
We have all found it, I think, very difficult to follow the alphabet soup. And if we could talk perhaps about parent banks, subsidiary banks, new banks, central bank, or something along those lines. It's easier than all the letters.
Make an adjustment accordingly, yes, my Lord.
I mean, it's maybe second nature to you now.
No, of course.
But I'm afraid it's not to us.
Yes, absolutely.
Thank you.
The second point then was that my clients, the subsidiary banks, were both depositors in the parent banks. That is an agreed fact, and for good measure, findings not challenged on this appeal by the courts below. If you wish to see the statement of facts and issues at paragraph 15, it's an agreed fact. Also 26 sub 3. It is also not disputed, of course, that our deposits were not transferred to the new bank, and our larger deposits, or the balance of them, never included in the depositor protection trusts.
And that follows as night follows day, doesn't it? That you have to get the 2.8 million transferred before there could be a transfer of a balance to the DPT. Is that right?
Well, I'm not sure is the honest answer to that. I see that the respondents, the first and second respondents, say we had no discretion to include someone who had not been the beneficiary of the first 2.8 million. But I say that is an odd approach which has the effect of compounding an injustice. If the government knows that if on the government's case, the government knows that somebody else has wrongly excluded 2 depositors from their first 2.8 million, is it really the case that they are compelled in law to compound that injustice and not protect those same depositors in the decisions for which they are responsible? So I would submit that one has to be careful about that.
Right.
And it isn't necessarily the case.
But am I right in thinking that each of the appellants had a single deposit with its parent bank and not as many deposits as it itself had depositors?
I believe that is correct.
So that what you're saying is that the first 2.8, there are 2 lots of 2.8 million
Yes.
that should have been transferred.
Yes.
One for one appellant and one for the other appellant.
Yes.
Even though there may have been that account with the parent may represent several thousand individual depositors, all of whom might be quite small.
Yes, I see that. I think that has to be the correct analysis, because we are saying we were depositors.
You were depositors.
And our deposits...
But your deposits with the parent didn't mirror the deposits that were with you. I'm stating it, but I'm asking as a question.
That is my understanding.
One big lump of money.
Yes.
Yeah.
Yes. The third point that emerges from the facts and the legislative framework is that we say it is clear that the respondents were all closely involved in a decision to exclude or a failure to include the appellant's deposits. The central bank, for its part, was required by primary legislation to approve the PAA, the purchase and assumption agreements, in writing before they were made, so as to dispose of the 2 banks' liabilities for those deposits. That's section 142 sub 2. They were also required to make a formal recommendation before the Chief Minister could lawfully make a vesting order, transferring the undertaking from Bank X to Bank Y. That's section 174 sub 3 on page 1808. And
can you give us the reference for 1422?
1422 is 1799.
Thank you.
And 1743, subsection 3 of section 174 is on page 1808.
174.3
Yes.
required the central bank to give approval.
The central bank must make a formal recommendation, and the word used is recommendation, and it's relevant to a point made by Mr. Knox, which I'll come to later. It's a recommendation, and we say, therefore, the Chief Minister must have a discretion whether to accept that recommendation.
And that's as a precondition to the transfers?
As a precondition to the vesting order.
The vesting order.
Yeah. And one of the things that we find remarkable, to be frank, is that we have never received either the central bank's written approval decision made under Section 142, or its Section 174 recommendation to the Minister, or for that matter, its investigation findings under that same provision. It was supposed to carry out an investigation before making a recommendation. In fact, we have nothing from the central bank about any decision it made about this case, or indeed any other document that is relevant to this case. There's been no disclosure whatsoever. So that's the central bank. The receiver was, of course, the legal person who could make the PA, the purchase and assumption agreements, and did so. That's Section 142 again. Again, we complain that we've had no disclosure of any internal thinking on that, any external consultation with the central bank or with any others, not even the agreements themselves. Not even, remarkably, an evidential assertion, for example, that this might be set out in an affidavit, that there is nothing to disclose, or that there is some candid explanation of the facts, which means that disclosure of documents isn't necessary. Of course, I accept that judicial review doesn't always require disclosure as such, but it does require candour of fact. All we have had is silence. The Minister was, for his part, responsible for making the vesting order, giving full legal effect to the transfers, if satisfied with the bank's recommendation, the central bank's recommendation. It is known that he did so, albeit quite a bit later than we on our side had originally thought. It was June 2020 when the vesting order was finally made. We don't know what the reason was for the delay, but on any view, he and the government of Anguilla more broadly were plainly closely connected with the resolution plan, and the Chief Minister is said to have worked very closely with the other respondents to give effect to it. So the summary is that all three of those respondents and/or the government were responsible under primary legislation for the collective decision, or decisions if there were more than one, as to whose deposits were going to be protected and whose were not, by being transferred into the new bank. That's the transfer. Then the deposit protection trusts, the government was a party to and one of the creators of those trusts. The trusts set out a schedule of former depositors in the parent banks, and the appellants were not included in that schedule. The government, we say, was responsible for that decision, having created the trusts which excluded my clients. Now, not only that, but the purpose of the deposit protection trusts had been clearly set out in legislation. The Obligations Act, as I will refer to, I think its full name is the Banking Obligations Act. Bank Resolution Obligations Act, said in Section 1 that these trusts were to be established and executed to protect as beneficiaries, quote, the large depositors of the parent banks. That's page 1777. And that's in the interpretation section, which is Section 1, second paragraph. By Section 2, the Act made the government of Anguilla responsible for the funding of the trusts by reference to a principal sum set out in Schedule 2. That's the next page, 1778 for Section 2, and then 1781 for the schedule, the relevant schedule, aggregate principal sum of $52 million. And it made the minister responsible for reviewing the adequacy of those funds. That's back, I'm afraid, to Section 6. If you read Section 6, subsection 1, the minister shall review the terms of Schedules 1 and 2, 1 not being relevant, whenever deemed necessary, but at least every 3 years, shall lay a report of his findings and make recommendations to the House of Assembly. And then subsection 2, for the purposes of the review and recommendation, the minister shall, and then C, monitor the ability of the depositor protection trusts to satisfy their obligations.
Where is Schedule 2 again?
So Schedule 2 is just a couple of pages on 1781.
How much were your deposits in Eastern Caribbean dollars?
I think there is evidence that they were 60 million US dollars.
What's
Yes.
that in Eastern Caribbean dollars?
I'm afraid I don't know, but I accept it's a lot more than 52 million.
I'm told it's about 2.6.
It's about
So $1 US equals 2.6,
Right.
thereabouts.
Yes. The central bank and the receiver, in all likelihood, also made relevant decisions bearing on the question whether subsidiary banks should be treated as large depositors within the meaning of the Obligations Act. Firstly, the receiver was a party to the DPTs as well, so we say equally responsible for the contents of the schedule. Secondly, there is some evidence the receiver had reformed the view that we were not real depositors, that the appellants were not real depositors, a point which is no longer taken. But it's Mr. Knox Casey's primary case that they did, or that they were in effect legally responsible for the decision that the appellants should not be included in the DPTs.
Do you accept that if the construction of the legislation is that it does not cover you, then whatever decisions there were taken afterwards to implement that can't be reviewable if they were really determined that choice had been made in primary legislation?
I think I have to. If it's the case that as a matter of law,
Yes.
the appellants could never have been included. It simply wasn't lawful.
Not whether they
Sorry.
could never, whether according to the legislation they are not included.
They are outside the scope of any permissible inclusion.
Yes.
If that were the finding of the court, of course, in effect, nothing else matters. There could have been all kinds of unlawful decisions made, or irrational or unfair decisions, but I suppose the analysis would be it makes no difference because you were never eligible in the first place. I do say, however, that it's a very strong thing to ask the court at the leave stage to determine that.
Yes, yes.
And that even questions of law, questions of whether whether there is or isn't a discretion, which my learned friend wants to raise, questions of whether it could have made any difference, they do require a factual context, which normally you would get in candid evidence at the substantive stage. You get information, for example, about what all of these very experienced public authorities made of the legislation. Of course, that's not determinative because it's for the court, but it might be useful information to know when considering the construction of an act. And there may also be evidence about how others were treated who may be in an analogous position to us. It is quite dangerous in my submission to dress up points at the leave stage as knockout blows without at least some adequate factual information about the decisions that were made. So, I mean, my short answer to your Ladyship's question is yes, it has to be. But I think what we say is it's just not a fair or a safe thing to be determined on a leave application without evidence, candid evidence from the respondents.
Right, so, but do you know whether there were other, if I can call the appellants offshore banks just for a moment, whether there were other offshore banks who did have their deposits with the parents transferred to the new bank?
I don't know for sure is the honest answer, but I accept that it rather looks as though, I mean, there is a list of deposits, there's a schedule at the back of the DPTs, which lists some names of companies. And of course, many of them, in fact, probably most, if not all of them, are not banks. So one of the principal submissions I make about this idea that, well, if you're not covered by the Banking Act, you can't be protected. Well, that makes no sense at all, because it's not banks who are being protected for the most part. It's depositors. The real question is, are we depositors or not? And that's been conceded. But the answer to your ladyship's question, I don't know. It may well be that the answer is no. But it would be the kind of thing that we would expect to see in evidence. Who were the people that were protected? Who were the people who weren't protected? Is there a consistent and fair line being taken in this regard?
Mr. Piewski, can you help me, please? You said that there were two reasons why it was likely that the central bank and the receiver made the decisions who were to be treated as the larger depositors.
Yes, the first reason was that the receiver is a party to the DPT. So actually, we say legally responsible along with the Chief Minister for a decision to not include us. The second reason is that there's some indirect evidence which we set out in the factual bit of our written case, that at a preliminary stage the receiver took the view that the appellants were not real depositors.
Yes.
Is that the placement?
Placement rather than deposits. And then I suppose the third point, and I hope it's not an unfair jury point, but it really did strike me, honestly, when reading Mr. Knox's case, paragraph 4 of his case, which is behind the fourth tab of the key documents bundle, it's worth dwelling on. Perhaps you need to read paragraph 3 first, because the paragraph 4 is the answer to the questions asked in paragraph 3. And I rely, or I note, with emphasis, the second sentence of paragraph 4. It was the ECCB and the receiver, the central bank and the receiver, who were responsible under the legislation for making the relevant decisions and who made them. And that's really the best evidence we have of what happened in this case. An assertion from the government before this court that the other respondents made decisions, but we've never seen the decisions. They've not disclosed the decisions. They know about them. And as I've said, unless I am misreading the third and fourth respondents' case, I apologise, I haven't already said this, but it is also striking that in the third and fourth respondents' case, they do not actually go so far as to deny having made decisions. There's no affidavit saying we did not make a decision. What they say, as I understand it, is that we, the appellants, can't prove they made decisions. That's paragraph 66 on page 1754. A different point, and rather an unfair one, in a judicial review context when the cards are not in our hands.
Paragraph 66.
Yes.
Yes, that the appellants have been unable to point to any actual decision.
Yeah, we have been unable, but we've been unable because there's been a lack of candour. And there is no, unless I missed it, in which case I apologise, there is no clear statement in any evidence from the third or fourth respondent, or even any pleading, that they never made any relevant decisions in this case.
If I may,
the fourth of 6 of my key points is that there was...
I'm sorry, if I could also add that paragraph 79 of the third and fourth respondents.
I'm so sorry, my lord, but actually I don't think we can hear you. Is there any way that the volume could be increased?
I'm sorry. If I speak slowly, can you hear me now?
I can just about hear you, yes.
I'm sorry. Paragraph 79 of at page 1758 also touches on exactly that issue. They say the recommendation and directive, if they existed, and would likely simply have recorded what was already known.
Yes. Yes,
So
my lord, that we say is...
They seem to be somewhat equivocal about actually saying whether they existed or as to whether they made any inquiries as to whether they existed.
My lord, I am so sorry, but for my part, I can't hear what you've said about that.
They're being equivocal as to
Yes.
whether those did exist or whether they've made any inquiries as to whether they existed.
Yes, absolutely right. The fourth point of the 6 key points is that, as I've mentioned, never any decision letter from anyone, certainly no reasoned decision explaining why we had not been included in the resolution plan. The fifth point is that pre-action there was a series of letters in which my clients asked a number of entirely reasonable questions, I would submit, about what had happened. And again, I just refer to our case at paragraphs 31 to 47. And I would respectfully ask your lordships and your ladyship to read those paragraphs for a sense of the pre-action chronology. Apologies if this is our fault, but when you see page references within our case, you may need to add 2 to get to the right document, because I think we were referring to the reproduced record, and then I think the practice is one adds an index. I'm sorry about that. So, for example, when we refer to paragraph page 698 in paragraph 31 of our case, it should be page 700 of what you now have as the electronic bundle. But that sets out what we say is a really troubling failure to respond candidly to pre-action correspondence. The modern approach is not to stay silent, refuse to answer questions, but to do what is fair and to reveal the necessary information for a claimant that is seeking to bring judicial review proceedings or asking about the public law legality of decisions that have been taken. And just for completeness, we did send one more letter to the government after proceedings had been commenced, asking further specific questions, and that's page 836 of the electronic bundle. You see that that's a letter dated the 6th of November 2019, and it's effectively responding to the affidavit of Mr. Harrigan that had been put in at the leave stage. And you see that a number of questions were asked on page 2 of the letter. Who made the decision not to transfer the liability? If a vesting order really hasn't been made, when is it going to be made? And then a question about the putbacks, because putbacks, it was being said, well, can't make the vesting order because the putbacks haven't been finalised yet. Well, when's that going to happen? And a number of other questions. And then the response to that is page 838 to 9, almost entirely unhelpful, opaque response. It's not one that I'm going to read out, but it is a repetitive series of bad points taken to purport to justify the refusal to provide information. We say this is wholly inadequate for a public authority facing judicial review proceedings, especially a government. And the sixth and perhaps most remarkable thing about the chronology is that, of course, the third and fourth respondents conceded before the judge that leave should be granted, or at least had no objection to it. And if you want the reference to the transcript, it's page 884, lines 3 to 11. To the extent a point is taken against me that there's a distinction between conceding that leave should be granted and not objecting, I say there is no material distinction. They said nothing, of course, about the facts. They appear at the hearing, say that leave should be granted, provide no documents or affidavits, And then, of course, we have the judge refusing leave, even against them, on the basis of legal arguments that were not put by them, and indeed were not put by any party. And we say that it was opportunistic and inappropriate for the third and fourth respondents then to seek to defend the judge's refusal of leave in the Court of Appeal, critically without improving their candour. It's one thing to not resist and not to provide documents because you're not resisting. But as soon as you say, actually, leave should be refused, surely at that point there is an obligation of candour. No affidavit at all or any other documentation filed by the third or fourth respondent in either of the courts below. So that's the facts and the if you like, the procedural chronology. Some brief points now, turning to my third overarching submission on grounds. We say that the grounds are plainly arguable. For your reference, the original application for judicial review leave is pages 8 to 30 of the bundle. We've tried to summarise them at paragraph 92 of our written case. That's page 1706. And if you like, to put it thematically, there are really three themes of our grounds. There is a theme to do with transparency of process and fairness. The decision to exclude the appellants from the transfer was not transparent or reasonable, as required by section 149, subsection 2 of the Banking Act, or as a matter of basic principle, public law principle. Indeed, one might think that by not writing a decision letter, a public authority falls at the first hurdle of transparency and reasonableness. There have been numerous opportunities to provide the official true reasons for what occurred, but none of the respondents have taken that opportunity. So that's transparency. The second theme is really unexplained differential treatment. There was clearly an inconsistency of approach, but no justification offered at the time, and instead a number...
I'm sorry,
Yes.
I've just caught up with 1492, which is on page 1803. That's to do with the sale of the assets, which isn't what we're concerned with, is it?
Any sale of the institution or the holding company assets, I would say we're within that because there was in fact a sale of the institution. But even if that's strictly speaking not correct, the intention of the legislation surely was that transparency and reasonableness were to be expected of the receiver's functions under section 142 and the central banks.
The licensed financial institution being spoken about here is the parent bank, is it?
Yes, I think it is. Yes.
What page is it?
This is 1803.
Thank you.
But as I say, the grounds are, we submit, wide enough to incorporate a general obligation under public law to provide, to act in a reasonable manner and to be transparent, at least in the sense of providing reasons for a decision of this magnitude. So that's transparency and fairness.
When this legislation went through the Legislative Assembly, is there any secondary material that explains who was supposed to be covered, or any announcements as to that?
I'm not aware of any. No, certainly none has been.
If the respondent's case is this is all mandated by the primary legislation, one wonders whether that was clear at the time it was going through the legislative process.
Yes. In the absence of such material, all we have is the words of the statute, and I would say that they're sufficiently broad to cover us because we're depositors. But yes, it is striking that there is no such material before the court. Of course, it may be that at a substantive hearing there could have been, and then we might have been into arguments about Hansard or the equivalent of, and whether it's appropriate to rely on. But we don't know what any such materials said.
You said there were three themes in the
Yes, so the first theme was transparency. The second theme was unexplained differentiation, or use the word discrimination, but obviously it's not discrimination on a protected ground, but differential treatment without any contemporaneous reasoning or explanation. And a number of, I'm afraid, shifting and inconsistent justifications put forward ex post facto by lawyers once the proceedings have been commenced, but with no real supporting evidence of the real reason. And a third theme is to do with promise breaking. The decision, we say, was contrary to policies and promises which the respondent had publicly articulated. So a breach of the principle of legitimate expectation or the well-established public law requirement for public authorities to act in accordance with their own policies, unless there's a good reason not to, as set out in cases like Mandalia, which is included in the bundle at 2379. The policy that was announced publicly on the 22nd of April 2016 was the logical extension of one that had been in place for a period of time before then. That is, it was to provide full protection for all depositors of the parents, and that's page 107 of the bundle, where, let's turn it up. It's just after the 4 points describing the new Banking Act. Chief Minister refers back to a meeting back in February 2015. The ECCB Monetary Council took the decision to provide full protection for all depositors of the CCB and the NBA. So this was a policy that was not new, but it was a continuation of a policy that the ECCB Monetary Council had previously articulated. And, of course, you have evidence from Mr. Tacon for the appellants that they had specifically been encouraged to carry on placing their deposits with the parents, despite the difficulties. And so in the circumstances, these are grounds that call for a response. They are arguable. They are, in the words of the threshold cases, they have a realistic prospect of success. But the fallback, as you know, my lords and my lady, is that even if it is unclear whether the grounds are arguable or sufficiently arguable, then the problems with candour and a lack of reliable information about the facts of this case do push it well over the threshold. And I don't want to labour the point, but we have it set out, the basic rule, at paragraph 93 of our printed case. That's 1708. And the subparagraphs in that paragraph, I could just use that as my theme, as it were. You have, of course, read it, but the general duty is really described in the first three subparagraphs. Very high duty to assist the court, full and accurate explanations of the facts, to make a full and fair picture of the decision-making. Partnership, cards are upwards on the table. You need to disclose the good, the bad, and the ugly. And it's not the same as hard-fought commercial litigation, as was said in the Belize case. The fourth point in the 93.4 in my case just mentions the comment in Belize that, of course, co-respondents and even interested parties may be subject to the same duties of candid disclosure, and that has resonance here, where two of the respondents are saying that they didn't make the decision, but the other two did, but they're not going to provide information either. And the fifth is also worth dwelling on. The fifth point, the Mid-Counties case, which in my submission is interesting because it illuminates that even if someone does not wish to object to a judicial review, they may have a duty to tell the court some basic facts so that the court is not second-guessing at the leave stage. And that's Mid-Counties, which is, sorry, I should have, reference has just escaped me for the moment, but it is in the bundle, I think. Thank you. It is 2651, and the relevant paragraphs 148 to 151 under the heading Postscript, and Mr. Justice Singh, as he then was, making some points about, I accept, a slightly different situation. Defendant public authority doesn't want to defend its decision in judicial review proceedings, perhaps because it can't afford to. That's not this case, of course. But the logic of it extends to a case like this one. And for the reasons I've articulated, the duty to assist us and to assist the court was not fulfilled here, either pre-action, as I've said, or at either of the hearings below. For the avoidance of doubt, I am not saying that we were entitled to full disclosure of every single document at the leave stage, but we were entitled to be told what decisions were made, by whom, when, and what the justification for them was at the time. So in a sense, there is, if you look, there's a push and a pull towards judicial review being granted. The push because of the obscurity of the decision-making that occurred on the facts of this case, and the reluctance to provide information about it, and a pull factor, which is that if leave were to be granted, it is crystal clear that there must be plenty of undisclosed material which could prove to be highly material or give rise to further or different grounds. And that is of itself a potential reason to grant leave. Now, the respondents rely on a passage of Lord Phillips in Marshall at paragraph 29, particularly I think the first and second respondents. If I could go first to what they say, page 1727. And paragraph 34(1). Could I just invite your lordships to read that, because then we don't need to turn up, I don't think, the case itself. And my learned friend wants me to ask you to read sub 2 as well, please. But that's on a slightly different point about a particular document. But if I may, taking it at a level of principle, what appears to be suggested is that candour may not apply or may apply with less force, or doesn't matter, when what is being said is that the public authority had no discretion in the matter. And I would say that cannot, in this case, provide an adequate reason for not having disclosed basic facts about the decisions. Firstly, it can't be the law, in my submission, that simply by asserting that you have no discretion, the public authority then has no candor duties, when that very proposition is one of the things that is in dispute in the case. The duty is owed to the court as well as to the parties. The court, as I've said, is going to be assisted by knowing what happened in outline, how the public authority actually approached the matter at the time, and whether it has acted as though it had a discretion in other similar situations. But even more, if you like, fatal to that idea in my submission is that the no discretion point can have no traction in a case like this, where there are a number of respondents, some of whom plainly did make decisions, and all four of them, or all three of them, know who did and what was said and when, and the claimants don't. On its own case, the government says that a discretion was exercised by the other respondents. So this is a case in which, in the words of Lord Phillips himself, it is not possible for the court to assess the merits of an issue that has been raised unless the public authority, we would say public authorities, against whom the claim is brought, furnishes the court with information which they alone are in a position to provide. And the third point, of course, is that I don't accept that any of the respondents had, quote, no discretion. I'll come on to develop this, but the government plainly had a discretion in relation to who to protect in the first place, whether and when to accept the recommendation to make a vesting order, what to put into the DPTs. Realistically, he also had a discretion as to what to tell the receiver and the ECCB about who should ideally be protected in relation to the smaller deposits. And the suggestion is equally hopeless in relation to the central bank and the receiver. They obviously did have discretion. They had a statutory power to enter into or ratify. Sorry, the receiver had a power to enter into, and the central bank had a power to ratify purchase and assumption agreements. The discretion extended to what exactly ought to be in those agreements. They had a power, discretion to publish recommendations for the Chief Minister under Section 174, and surely a power to influence, if not determine, the contents of the DPTs. So that suggestion at paragraph 34 of my learned friend's
Do you accept then that if their basic point on construction, which is that it was not possible under this primary legislation to include your deposits, that there was then a discretion to be exercised by someone as to whether to include them or not? Well,
I'm not sure I could put it in that way. If as I understand your ladyship's question, it would have been unlawful to include us, then...
Well, that's a bit of a loaded word, but their case seems to be whatever decisions we took were mandated by the legislation. Whatever decisions we took about excluding you were mandated by the legislation.
It's a power under legislation, isn't it? It's not mandated, it's a power that they have under Section 1.4.
Yes.
But if they are actually, on your construction, exercising a power, as my lord says, to decide who to include and who not to include, then you say they acted unreasonably in deciding to exclude us.
Yes.
But are you saying that under the legislation they had to include you?
I am saying that they did have to include us, but that even if that's wrong, they had a discretion to include us, and they've exercised it for reasons that we don't know about. And so that is where candour comes in. And it is effectively a no-difference argument that is now being run, that no matter what we did, no matter how irrational or unfair our decisions were at the time, it wouldn't have made any difference because we're now going to say, or we now say, that the legislation didn't extend to you. And I think I've said what I can say about that, which is that firstly, that is not an appropriate point to be decided at the leave stage. And I'll come on to say why it's wrong. Obviously, that's a main plank of my case, is that it's wrong. But in order to assess whether it's right, one surely needs to have basic information about what the approach was.
Why do you say that they had to include you?
Because
would it not have been open to the government and to the central bank within the structure of the Banking Act to say that they wanted to protect domestic depositors and that therefore they were able to distinguish the subsidiary company's position because of the nature of their activity.
Well, we would have said that that wouldn't have been lawful or fair because we are domestic, we're incorporated in Anguilla. It is true that our own depositors are offshore.
I understand that. I understand that you say you qualify in that sense.
Yes. But in the same way that a company that maybe have its registered address in Anguilla but may actually be making all of its profits somewhere else, the legislation does not discriminate between or it's not interested in the origin of your deposits. If you're a depositor in these banks...
I understand your case that there was to this extent that there was a discretion,
yes.
And you say it was exercised unfairly.
Yes.
But I don't know where you find the obligation to include you.
Well, I suppose
in the statutory scheme.
Maybe I couldn't say that it was obliged from the words of the statutory scheme. That would be perhaps putting it too high. But that a fair and reasonable decision has to be shown to have been made. And that hasn't been done in this case. And that's all we've ever been asking for. We want a reasoned decision that we can at least understand the basis for actually having excluded us. So that it can be scrutinised as to whether it's fair and reasonable and lawful. Now, I've reached the point where I was going to deal with the principal arguments made against us. I hesitated about whether I should leave these for reply or try and attack them now, but they are quite important, and they weren't all capable of being addressed in my printed case. So I think we are in good time, so I'm going to do that if that's convenient. In effect, can I start with the third and the fourth respondents, because if you like, that's a very important point is being made by the third and fourth respondents, because they say, as we've been discussing, that the appellant's deposits in the parent banks were never eligible for protection under the resolution plan by operation of law. And I do make a couple of preliminary points about that. Firstly, it is very odd that if that were the answer to the case, the third and fourth respondents did not articulate that to the judge. They attended the leave hearing and said to him, we do not object to granting leave against us. Secondly, I've already made the point that this is not what the government say. He does not endorse, Mr. Knox does not endorse in my submission, that part of the court's reasoning below, or the third and fourth respondents' case before this judicial committee, involving the proposition that no decisions ever needed to be made because exclusion was automatic. And I've made that point, I think.
Does this point first appear in the judgment of Mr. Justice Innocent?
I have to hesitate because Mr. Justice Innocent referred to a number of different points, some of which it is accepted were incorrect. Offshore depositors, transfer to NCBA, and so on. I think, being as fair as possible, he saw the offshore aspect as relevant, but didn't put it quite in the way that the third and fourth respondents are now putting it. What they say is the appellants are simply not covered by, regulated by the Banking Act. They're outside the scope of the Banking Act and therefore they don't qualify. And that's the case I have to meet. But it's not quite the same as the point that Mr. Justice Innocent made, which, as I understood it, was that the appellants, were themselves offshore, or that their deposits were offshore and somehow didn't qualify, or that we were in administration at the time, a point which the Court of Appeal appeared to have found more weighty and appeared to be the principal basis upon which the Court of Appeal thought our case was not arguable. But as I understand it, the third and fourth respondents don't principally run the case on that basis. And so a large part of my printed case I don't really need to dwell on, because we say, why on earth would you exclude, would it be a rational scheme to exclude people who happen to be in administration? That just doesn't make any sense at all. The key point, we say, is this. The legislation simply does not impose any requirement that in order to be eligible for protection under the resolution plan, you have to be a depositor who is carrying out regulated activities under the Banking Acts. No one can point to any restriction that says that. Yes, of course. Yeah.
It's not required that to be eligible, you have to be a depositor
who is carrying out regulated activities under the Banking Acts. The reason I'm addressing that is because, as I understand it, the third and the fourth respondents say you are not covered by the Banking Acts because you take deposits
there must have been a Banking Act before the 2015 one. So the business they were carrying on was actually carried on under that earlier Banking Act, presumably.
Yes, presumably. Yes, I believe that's right. But the Banking Act simply does not restrict eligibility in the way that is suggested. It's simply, we've seen references to Section 142 of the Banking Act. It allows the receiver, page 1799.
Mr. Fiscate, could I try again? Can you hear me?
Yes.
Yes. But I had some difficulty with this argument insofar as all the depositors with the parent banks obviously weren't regulated by anybody at all. And so why the question of regulation affects whether you're an eligible depositor totally escaped me. And there's no legislative provision, as far as I could see, restricting eligible depositors to people who are regulated.
Correct, my lord. With great respect, that is exactly it. And not only that, there's no express limitation on who is to be protected, either in the Banking Act, or in the Obligations Act, or in the Trust Companies and Offshore Banking Act. We haven't been to that yet, but at page 2032, that actually is legislation which helps us, because what that does is explain that when we bank as depositors, as domestic depositors, we are subject to the Banking Act.
So what page was that?
2032.
Thank you.
Sorry, that's the heading, and then the provision that I'm after is 2038. And it's, starting on 2037. For greater certainty, a person, including a domestic bank that holds an offshore banking license, 1, is exempt from the provisions of the Banking Act in respect of offshore banking business, and 2, is subject to the provisions of the Banking Act in respect of banking business other than offshore banking business.
Sorry, you're reading 2037.
I'm reading section 2.2, which starts at the bottom of 2037 and goes on to the top of 2038.
But I don't think you did any banking business other than offshore banking business unless you count your deposit with your parent as banking business. But do you?
I think that's right. But I think that is it. So when we bank,
do you count it as banking business?
Yes. I'm sorry.
Do you say that your deposit with your parent of all your money or all your customers' money is banking business other than offshore banking business, or is that not really banking business at all?
Well, it is our case that it is. I mean, I don't think we need to say it, but to the extent if your lordship is attracted to the idea that in order to be within the scope of this protection regime, you have to be subject to the provisions of the Banking Act in relation to your activities as a depositor of the National and the Commercial Bank.
But most depositors won't be subject to the Banking Act.
Exactly, and that's why, as a matter of policy, the submission makes no sense at all. I'm sorry if I'm labouring the point.
That's right. The parent was not just holding its subsidiaries' deposits, it had direct depositors with bank accounts with it.
Yes. Demand deposit accounts, which are described in the accounts. I can try and find the reference to that, but we had deposit accounts with the parents. And my lord, you have the point. Standing back from the respondents' submissions, many, if not most, if not all of the protected depositors were not engaged in banking activities at all. So they were not subject to the Banking Act in the way that the third and the fourth respondents seem to be saying that we needed to be. And if you want a list of depositors, finally got there, it's page 776. That's a list of people who appear to have benefited from the DPT protection. And they are...
This is the schedule, is it?
This is in the schedule. They are individuals... I'm sorry.
They're not all banks.
They are certainly not all... Well, they are not all banks. In fact, they are mostly not banks. There's an insurance company, there's a reinsurance company. There is one, on 775, there is Charter Capital Limited. I don't know whether that's a bank. Sounds like it could be. There is Caribbean Credit Card. We're not sure, but it's certainly fair to say they are by no means all banks. And then the only other point that I don't think I've addressed from the third and the fourth respondent is a point about alternative remedy, and I think I can deal with that quite quickly. The point is made at paragraphs 82 to 88 of Mr. Dennis of King's Counsel's skeleton argument that judicial review should in any event be refused because we had an alternative remedy. And this is the first time, so far as I'm aware, that this point has been raised, and it is misconceived. The appellants were entitled to bring a private law damages case to test their allegation that following appointment in 2013, the conservators of the parent banks had acted in breach of their fiduciary duties owed to the appellants by allowing some of the appellants' funds to be placed with the parent banks, who were already struggling, because this exposed the appellants and their own depositors to a high risk of non-payment. That, in effect, was the nub of the appellant's case in private law. But it is not fair or correct to suggest that the premise for that private law claim was that there had been a wrongful exclusion of our deposits from the resolution plan as a matter of public law.
So is this on the basis that there was nothing fundamentally wrong with your business? Your businesses were not at risk of insolvency, and therefore it was wrong for the conservators to throw your lot in with the parents who were struggling, is that?
Yes, I'm not across the detail of the precise breaches that were alleged, because what one can see from the judgment is that the court, and we've not appealed this decision, rejected the argument that they owed fiduciary duties at all. So the claim failed. But insofar as there was any claim against the ECCB, the central bank, it was a tracing claim, and the finding of fact there was that the ECCB, the central bank, had not received any money that belonged to us. So these are, all I'm saying is these are completely different claims, good or bad, found to have been bad by the judge, and the idea that that was a suitable alternative remedy for public law complaints against the government and the central bank and the receiver is absurd. They're different claims. They relate to different sums of money, because we're saying that all of our deposits with the parent banks could and should have been considered for protection under the resolution plan, whereas the sums of money that were in issue in the private law claims was a much more limited class. It was the sum of money that had been taken within a period relating to when the conservators were in charge. So, in a sense, what I say is that this is not an alternative remedy objection at all.
If you had brought an alternative, if you had brought a private claim against the conservators for the larger sum of money, presumably you would have lost that on the same basis that there was no fiduciary duty.
That would have been very difficult in relation to sums of money that predated their alleged misconduct. That would have been a non-starter.
Yeah.
We can't reasonably be expected to have, that wouldn't have been an adequate alternative remedy, we say. But I think I'm right in saying this isn't really an alternative remedy point at all. It's more an issue estoppel point. The claimants aren't saying you had an alternative remedy, you failed to exhaust it.
No, I mean, you don't normally argue alternative remedy in a case where where a remedy has been sought unsuccessfully.
Well, exactly. We did exactly what...
So it's more like issue estoppel or res judicata.
No. So I don't wish to take a sort of... that's not my only objection, of course, but it's the first point is that it's a confused submission with great respect, and what it really is some form of an estoppel point, but it can't possibly be right because the issues are not the same. The issue is a private law issue relating to different sums of money, relating to different defendants, and the fact that success in that claim might have affected the quantum of this public law claim is nothing to the point. It's not an issue estoppel. So that's all I wish to say, unless you have any further questions about the third and the fourth respondents' case. And we say we've established that the leave should have been granted against them.
The argument based on receivership of the subsidiaries, is that a point that's no longer taken against you?
Forgive me, my Lord.
Administration.
I'm sorry,
Yes.
I'm sorry, the administration of the subsidiary companies.
I don't
resulting
understand.
in the exclusion of those subsidiaries from the protection scheme by operation of law.
I don't understand that to be a point that is now taken against us. If I'm wrong, I'll address it briefly in reply, if that's convenient. It can't be right for a number of reasons, but it's not. On the government's case, then, finally, turning to my final, if you like, chapter of submissions, which I hope have not been too long or repetitive. The government's first submission is that the receiver and the central bank are solely responsible for what goes into a purchase and assumption agreement. Nothing to do with the government, they say. And the problems with that are, number one, Section 174 of the Banking Act plainly gives the minister the power to validate that sort of decision, the transfer of the liabilities from the parent banks to NCBA. The second point is that we know that the minister did validate it in that way, albeit later than we originally thought.
Is that by the vesting order?
The vesting order, yes. And that was disclosed to us, I believe, shortly before the hearing in the Court of Appeal in January 21. It had been made in June 2020. So the government now says, and this is the third point, well, there was never any need for a vesting order. And that is flatly inconsistent with what the government told the courts below. The judge was told not that there was no need for a vesting order, but that a vesting order could not be made until the, quote, putbacks, which, as I understand it, are adjustments to the detail of the PAAs, had been finalised. References to that are 746, page 746, paragraphs 14 to 15. And also page 878, paragraphs 5 to 6. These are just paragraphs from the evidence of the government that was put in at first instance. That was first instance. Similarly, at the Court of Appeal stage, even after the vesting order, the government was saying to the Court of Appeal that the judicial review was premature because at the time of the commencement of the judicial review, no such vesting order had been made. We say a highly unusual and unattractive position to take, that at the time you started, you didn't realise it, but we hadn't actually made the decision you're complaining of, which we made later, but now you shouldn't get leave because we hadn't made it at the time you started. But I'm not dwelling on that because that's now an issue. I'm dwelling on it because it's very different from the point that's now being made, which was that a vesting order never needed to be made in the first place. We even have at the hearing leading counsel saying to the Court of Appeal, quote, "The Chief Minister was saying all along, once he has a recommendation from the central bank, he will make the vesting orders." Page 1312, lines 1 to 3. So it is extraordinary, we say, that having told the courts that and having made a vesting order, in the midst of this litigation, he comes to this final Court of Appeal and says, well, actually, he didn't need to make one at all. But the key submission really is that even if he is right about that, and with great respect, he isn't right about that, even if there was no requirement for a vesting order, once he chose to make one, he gave the government's formal statutory blessing to what had happened. He has made a vesting order which is unlawful to the extent that it accepts and endorses a recommendation by the central bank based on earlier decisions which were themselves unlawful. That's the argument. The second point made against us is that the minister had, as a matter of law, no power to refuse to make a vesting order once the central bank had recommended one. He was, quote, implicitly required to do so. That's paragraph 32 of my learned friend Mr. Knox's case, which is on page 1727. And the short answer to that is that it involves a completely untenable reading of section 174, not least because the minister has a discretion whether to accept the recommendation of the ECCB. Again, the page reference, if you want it, is 1808. But to imply an obligation on the minister to accept a recommendation means that it's not really a recommendation.
Well, he's just saying he was really just a rubber stamp, and therefore...
In my submission, that is plainly untenable reading of section 174. For good measure, if you look at the vesting order, which is page 1175, this is one of the vesting orders. Of course, there are two. This is the National Bank of Anguilla vesting order. The first line says, in exercise of the power conferred under section 1743. There you go. I mean, except my lady's point could be a power which is really just a power to rubber stamp, but it certainly looks as though a power rather than a duty is accepted as being exercised. A slight variation on that point is that even if it isn't required as a matter of statutory interpretation, I think the government says that on the facts of this case, the minister couldn't reasonably have refused to make a vesting order because of the adverse impact on those people who ought to remain protected. But that doesn't work either, in my submission. The minister could plainly have said, this recommendation is not accepted. You need to go back and include all eligible depositors, or explain why you have included some but not all before I make a decision. Of course he had a choice. It is quite hard to square some of these submissions running together, because the attempt to say that a refusal would have had a potential impact on other depositors is not easy to square with a submission I've already dealt with, which is that the vesting order was completely unnecessary in the first place. There is then a submission that we, the appellants, didn't specifically ask the Court of Appeal to quash the vesting orders. And that is, with respect, unsustainable for a number of reasons. We were asking the Court of Appeal to allow an appeal and grant us JR leave. We were not asking and couldn't ask the Court of Appeal to quash anything at that stage. As I've said, it was only revealed to us in January 2021, and that was long after our notice of appeal had gone in and written submissions had gone in, so that's why they didn't mention the vesting order that had been made.
It was only in January 21 that you were told that the vesting order had been made.
I'm so sorry?
You're saying that it was only in January of 21 that you were told that the vesting order had been made?
I think that's right, yes. It was disclosed to us shortly before the oral hearing in the Court of Appeal. So that's at least why the written arguments, when the written notice of appeal, which predated it, didn't particularly address the vesting order that had been made. But the whole point of the appeal was quite obviously that we were asking for leave in relation to exclusion decisions in whatever form, in whatever format. And we were saying that, look, the vesting order has now been made. The government respondents, we say, understood this perfectly well, because the answer that they gave was similar to the one that I've described before, that once the bank had recommended the vesting order being made, he was obliged to do that in June 2020. And so that was an indication that he understood the point that was being made. We were saying, you've made the vesting order, you must have made the exclusion decisions that are part of that. And his answer was, well, I had to. And so it doesn't then make sense to say, well, the appellants didn't ask the Court of Appeal to quash the vesting order. They understood that we were asking the Court of Appeal to grant leave in relation to any form of the exclusion decision that we had identified as embodied in the vesting order, and they answered that submission on the merits. The fifth submission from the government is one we've touched on already, which is this interesting point about whether there is power to include in a DPT a depositor who, for whatever reason, has not already been included in a PAA. My learned friend would say it's a top-up vehicle, the DPT, and all we needed to do was look at the list of people in the PAA and see whether they had deposits over 2.8 million. And as I've said, my submission is that is an unprincipled and unsustainable interpretation of the Obligations Act, which defined the trusts in a deliberately broad way, as we've seen. The legislation could have said depositors eligible for protection are those whose deposits have already been included in a PAA by a receiver, but it didn't say that. This is another submission that is crying out for evidence. You would want to see an indication that every named depositor set out in the DPTs also had smaller deposits that were transferred to NCBA. We don't have that. And as I've said, it's an unjust consequence of that submission. it is very unlikely to have been intended. It effectively requires the government, when jointly creating the trusts, to compound an existing injustice about which it knows by failing to include a large depositor for the sole reason that his smaller deposits have wrongly not been transferred to NCBA, and that can't be right. Again, though, even if it is right, it doesn't matter in this case, because if and to the extent the central bank's, the receiver's decision were shown to be unlawful, then the reason for the appellant's exclusion from the trusts would be because of the unlawfulness on my learned friend's case, and so the DPT exclusion decision would itself be infected by that illegality and would itself be unlawful. The sixth, and I'm nearly at the end, there are 7, I think. No, there are 8. The sixth point is that the funds required to be placed in the trusts by the Obligations Act are not going to be enough to cover our large deposits, says Mr. Knox, and so it can be inferred that the intention was that our deposits would never be protected. First point we make about that is there is no evidence about how, when, why, or by whom the 52 million sum mentioned in the Obligations Act was chosen and what it was supposed to cover. You would need that information to adjudicate fairly a submission such as is made by Mr. Knox. Secondly, as we've seen, there is no good basis in law for assuming that the legislation intended for the government only to have one shot at funding the DPT, the trust. On the contrary, as we've seen, Section 6 expressly requires the Minister to review the terms of Schedule 2 whenever deemed necessary and to monitor the trust's ability to satisfy its obligations. So there can be a top-up if the total amount set out in paragraph 1 of Schedule 2 turns out not to be sufficient. And the final point is that even if all of that is wrong, there still needed to be, on my learned friend's case, there would still need to be an exercise of judgment by someone, reviewable on judicial review principles, as to what to do about this problem, if it really is a problem. It cannot be said that the inevitable conclusion would have been that we should be excluded from the trusts because our deposits were, for example, too large.
When the amounts are transferred to the, or the amounts that are not transferred under the PAA and which therefore fall to be paid off under the trust, that's a fixed sum, is it? It's not a sort of ongoing deposit. It's a sum which is, subject to interest payments, whatever, but it's a sum that is fixed as at that date, so everybody knows what that amount is.
I think that is the case, yes, that there is a number, which is the total number, and the first 2.8 million is supposed to go to NCBA, and the balance over that is supposed to go, this is in a situation where it's all working as it should, it's supposed to go into the trusts and not available for immediate access. I think that is right. The penultimate point, I think, is that Mr. Knox says our legitimate expectation claim has to fail for 2 reasons. One is no evidence of detrimental reliance. Second point is government's promise insufficiently clear and not unambiguous. And on reliance, I'm afraid that is wrong in law, what is said. The current position is that it is not, the claimant does not have to show detrimental reliance in order to get a legitimate expectation claim up and running. See the Supreme Court's decision in Finucane at paragraphs 69 and 72 per Lord Kerr. And if you're interested in the wider reading, as it were, Lord Carnworth's concurring judgment, reconsidering some of the things that His Lordship said in an earlier case. It is, of course, relevant, detrimental reliance, potentially highly relevant to the question of justification. Your Ladyship recall 2 stages in a legitimate expectation claim. 1, has it arisen? 2, is it justified for the government or the public authority to resile from the promise? Detrimental reliance may well be relevant to issue 2, but it's not required for issue 1. On justification, my learned friend's suggestion that the government would inevitably prevail on that is also wrong in law, because the law is clear, as explained by Lord Dyson in Paponet, at page 2238, that it's for the public authority to put in specific evidence explaining why it departed from the promise and why it was proportionate for it to do so. It's particularly paragraphs 38 to 39 and 41 to 42, and the page number is 2251 to 3. And the final point is that they're wrong on the facts, because there is evidence of detrimental reliance, as Mr. Tacon explains, at pages 60 to 64 of the bundle, paragraphs 67 to 74.
Sorry,
Paragraphs 67 to 74 of Mr. Tacon's witness statement, explaining how he did, or the appellants did, rely on the policy or the promises that had been made.
Paragraph 72 of Finucane is expressly obiter. Lord Kerr says, since the matter doesn't arise, it's better for the point be addressed in a future case. This is whether the resiling from an undertaking would cause detriment.
Yes, but I had read 69 as explaining that the relevant principles are as set out in the Bangle case, which says that it's not essential that the applicant should have relied on a promise to his detriment, although this is a relevant consideration in deciding whether the adoption of a policy in conflict with the promise would be an abuse of power.
Yeah, I'd have to look at Banku. I may be out of date. The days when I used to do this stuff, the distinction drawn was between procedural and substantive legitimate expectations, and reliance was necessary to support a substantive legitimate expectation, but not a procedural one. That was the sort of common understanding at the time, but life may have moved on.
Well, my understanding is that the current law is that it is relevant to stage 2 and not stage 1 in substantive legitimate expectation claim.
So when you say stage 2 and stage 1, stage 2 is
justification.
Stage 1
is whether the conduct of the public authority has given rise to a legitimate expectation in the first place.
Thank you.
But in a sense, my Lord Reid might remember the case of Mandalia. We're in it's interesting because Mandalia seems to set out or summarise another line of cases which is equally relevant, which is that if you have a policy, you ought to apply that policy unless there's a good reason for not doing so. And the question of what does the policy mean is an objective question for the court. So it may be that there's a shortcut, that if your ladyship agree with us about what the policy was, then it is simply a question for the public authority to show what the good reason was for departing from that policy. And that requires evidence, and that's why leave should be granted, because there is no evidence.
It isn't an essential part of your case, is it?
I'm sorry?
It's not an essential part of your case.
No, I'm sorry to labour it, but it is notable that it is the only one of the grounds that we raise. You recall I've set out the 3 themes. My learned friend Mr. Knox only takes issue or only attacks the legitimate expectation one, unless I've missed it. He doesn't attack all the others. But I wanted to explain why he's wrong about the legitimate expectation claim being arguable. And really, there's just, I've been handed a little clarification before I sit down. In relation to the $2.8 million, I'm reminded that we were entitled to 3, if you like, tranches, because we had deposits with both, one of the appellants had deposits with both parents, and the other appellant only had one. I think it would probably be helpful if I clarified exactly who had which with, but if that's acceptable, perhaps I could sit down, clarify that over lunch, and then mention it in reply.
Yes. Yes, thank you very much.
Lords, unless there's anything further, my lady, those are my submissions.
Yes, thank you, Mr. Pesky. Yes, Mr. Attorney.
My lords, my lady. My lord, if I could begin by making a few short preliminary points before getting into what I would characterize as the crux of the matter, insofar as the third and fourth respondents are concerned. And the first has to do with my learned friend's submissions in relation to the posture of the third and fourth respondents at the stage of the application for leave. At that stage, there was indeed no opposition to that application. And my learned friend's submissions, both in his written case and indeed in his submissions this morning, would seem to suggest that that implies that somehow that amounted to a concession by the by the third and fourth respondents, that leave ought properly to be granted. However, non-opposition simply meant that those respondents were not adopting a posture where they were actively participating in the proceedings. And there was nothing unusual or strange about that in the context of the applicable provisions of the Civil Procedure Code, and indeed in terms of what was standard practice. The receiver and the ECCB did not oppose the application for leave. In a nutshell, my lords, because they simply took the view that such applications, which are typically and customarily heard ex parte, was really a matter between the applicant and the court, which, regardless of the position taken by a respondent, in any event had to satisfy itself that leave for judicial review ought properly to be granted. My lords, it is in this context that the receiver and the ECCB did not oppose or participate in the proceedings at first instance. And it is really quite erroneous and misleading to suggest that the receiver and or the ECCB conceded in those proceedings that permission for judicial review should be granted.
I don't think it's.
There was indeed no
It's
such
not put that high.
There was no concession.
No.
There was no such concession. So, in that context, my lords, the learned trial judge was required to examine the material which was before him and make an assessment as to whether he was satisfied that leave should be granted. And indeed, that is precisely what he did. And there are several areas in his judgment where he makes the point, the posture of the third and fourth respondents is one of non-opposition. However, I am obliged, notwithstanding that posture, to assess what is before me and determine whether or not leave ought properly to be granted or whether leave ought properly to be refused. And indeed, my lords, the mere fact that the third and fourth respondents did not appear and oppose the application for judicial review at the lead stage does not imply and does not mean that the applicants were relieved of their obligation to satisfy the court that this was a fit and proper case for the grant of leave because they had met the threshold test of an arguable case with a realistic prospect of success. They were not relieved of that obligation, nor did it preclude the respondents, notwithstanding their non-opposition at that stage, from defending the decision of the learned trial judge, who obviously gave careful consideration to the matter and delivered a judgment which lucidly set out what we say are unexceptionable and unimpeachable reasons for arriving at the conclusion which he ultimately arrived at, that this was not a case in which the applicants had met the threshold test, because in the final analysis, there was no evidence before him and he was not satisfied, particularly having regard to the applicable statutory regime, that the complaints of the applicants arose by virtue of actual decisions which had been made by the third and fourth respondents, but rather
I was wondering,
that the
Mr.
circumstances
Dennis,
of
sorry.
which they were
I do apologise, Mr. Dennis, but could you possibly assist me as to whether the receiver and the central bank did make decisions?
I'm sorry, my lord.
He's asking whether they did make decisions, the central bank and the receiver. Did they make decisions?
Yes. So the question of whether the central bank and the receiver made decisions in relation to these particular deposits which are in issue. Our case is that neither the receiver nor the central bank made any actual decisions in relation to the deposits in question, because, having regard to the statutory regime, they had no authority to make any such decisions.
And what part of the statutory regime are you referring to? Because at present, I understand that there is a power to decide who shall be included in the purchase arrangements and who should be excluded.
That is so, my lords.
Yeah.
The
did somebody make a decision to exclude the appellant as depositors?
Well, my lords, a distinction has to be drawn between the power on the one hand to make a particular decision and the issue of whether any such decision had in fact been made. Now, our case is...
If I could just follow up, because I understand that the receiver can only enter into the purchase arrangements on the recommendation of the central bank. And so both of them have got to make decisions.
It is so, my lords, that the receiver would act on the recommendation of the central bank.
But did the central bank make a recommendation?
Recommendations. But the pivotal point, my lords, is that the authority of the central bank to make any recommendations about including deposits in the resolution plan was circumscribed by the Central Bank Act of 2015, which was enacted.
Which provision in that act circumscribed his ability to make that decision?
My lord, the Central Bank Act, I'm sorry, my lords, the Banking Act, not the Central Bank. I was going to ask.
Yeah.
The Banking Act confers certain powers on the central bank, which is the regulator of all banking operations within the Eastern Caribbean Currency Union. The central bank has authority over banks who are engaged in domestic banking business in the various jurisdictions. The central bank's authority, however, does not extend to banks which are not conducting domestic banking business. Banks within the territories who are conducting banking business, which included deposits in foreign currency from non-residents of Anguilla in this case, are governed not by the central bank, which derives its authority from the Eastern Caribbean Central Bank Agreement Act, but from the Financial Services and Trust Company Act, which is a different statutory framework for governing banks which are involved in offshore banking business. And so,
but in this case,
yes,
we're concerned with domestic banking. These are deposits held with domestic banks. The depositor is a bank which carries on offshore business, but the deposits are deposits held with the domestic banks.
Well, my lord, on the face of it, that would appear to be the case, and that indeed is the case of the appellants. However, my lords, as I will show your lordships in due course, the operation of the subsidiary banks who were involved in taking deposits in foreign currency from external sources was conducted in circumstances where the conduct of that offshore banking business involved the upstreaming of funds which were placed with them on deposits to the parent banks. And indeed, my lords, my lady, one has to understand the context in which this was operating in order to appreciate the point.
Well, that word upstreaming, which is not a word that I've come across as yet in these, that seems to be intended to avoid the word depositing. So is it your case then that these were upstreamed to the parent and were not deposits?
Well, it is what I would say, my lady, when I say it was upstreamed.
Yes.
It is in this context. The parent banks were, as a matter of law, authorized to conduct only domestic banking business. They were not authorized to conduct offshore banking business in the sense of accepting deposits in foreign currency from non-residents. The subsidiaries were wholly owned subsidiaries of the parent banks. And these subsidiaries were incorporated by the parent banks through which offshore banking business was conducted. The parent banks were, or rather the subsidiaries, the offshore banks, were wholly owned by the parent banks, and their establishment was in order to facilitate the conduct of offshore banking business, which they themselves, under the Banking Act, was not allowed to do. And so, the way in which the subsidiaries conducted their offshore banking business, holding foreign deposits, would be that upon receipt of funds from their foreign depositors, those funds would be paid into the parent banks. The parent banks, who were then holding those funds, operated what were called, designated, characterized as intercompany accounts. Those funds which were paid into them by the subsidiaries were then used by the parent banks in order to facilitate transactions on behalf of the subsidiaries. The conduct of the operations of the parents and the subsidiaries were in fact being conducted in circumstances where there was no discernible distinction between them.
But was the parent, did the subsidiaries have accounts with the parent?
Well, the way in which it was done, my lords, and
a banking account, I know.
yes, and this is what the ECCB found when it took the parent banks over during the initial period of the intervention. What they found was that the books and records reflected not deposits as one would ordinarily understand them, although for purposes of the analysis in this case, deposits, the term deposits have been used.
But that's pretty critical.
Yeah.
Are you denying that are you denying that the subsidiaries were depositors?
What we say, my lords, is that they were not depositors in the sense in which that would ordinarily be understood, because the whole scheme and the whole way in which offshore banking business was being conducted by the subsidiaries was that those funds would simply be paid into the onshore banks, their parents, and then those monies were used as part and parcel of the umbrella operation of the onshore banks.
But isn't that the case with every deposit with a bank? The money, I pay my money into the bank. It doesn't sit there in a segregated fund. It goes into the bank's assets, and they do all sorts of interesting things on it to earn money for themselves. What they have to do is pay it me back if I ask for it. Why is that different?
That is so, my lady. The distinction here, my lady, is that the mechanism by which the offshore, by which the subsidiary banks operated offshore banking business was simply a part of a device, we say,
are you really denying that they were
by the parent banks.
I mean, you're really saying that this is all, that in reality there's a single banking operation going on, and because of the inability of the parent banks to carry on offshore banking directly, they carry it on nominally through a subsidiary, but in reality it's all the same business.
Precisely, my lord. It was a mechanism, it was a device.
A device.
It was an artificial device to circumvent the provisions which prevented the parents from conducting offshore banking business. I'm sorry, my lady.
I mean, this is an argument that I don't think we've heard until now. And you're really taking issue with the application of the legislation dealing with the protection of depositors on the footing that the subsidiaries were not depositors at all within the meaning of that legislation. Either they were a sham, or insofar as there was some genuine banking business going on, it wasn't of a character that falls within the scope of the term depositor as it's used in this legislation.
Yeah, yes, my lord. The point we make in relation to that is that because these funds, when these funds were paid into the parents, because of that scheme, because of that artificial device, those funds which were paid into the parent banks did not lose their essential character.
Mr. Dennis, I'd be grateful for your assistance. You, I think, are saying that the arrangement being carried on by the parent banks, was a sham, a device. And if that is so, then what action did the central bank take to monitor that at the time? To me, it appears to be an entirely new argument, and one which then would lead to a lot of subsidiary questions as to what action the central bank took to prevent a sham from taking place.
Well, my lords, the way in which the operation of the subsidiary banks was being conducted through the parent banks was something which the central bank only became aware of when, because of the circumstances which led to its intervention, it conducted its investigations into the operations of the onshore banks.
But there's no evidence. There's no evidence about any of this.
Into which it intervened. My lords, we do have in the papers and in the bundle before your lordships the decision of His Lordship Justice Moise at first instance in the proceedings brought by the receiver against the Eastern Caribbean Central Bank, the conservators of the Eastern Caribbean Central Bank, and the receiver, in which these issues were live issues. And we do have...
You'll take us to that in a moment. Can I ask, first of all, does this find... Is this raised in your written case?
In the written case, my lords, we deal with the question of how the funds were treated in the context of our submissions concerning whether or not the exclusion of the onshore banks, the subsidiaries' deposits, occurred by way of operation of law or by an actual decision of the receiver or the central bank. And we deal with that, my lords, after dealing with the legislative framework, and in particular at paragraph 62 of our submissions.
Paragraph 62 contains no reference to that. And indeed, paragraph 79 indicates you don't know what the reasons are. You just make an assumption.
I'm sorry, my lords, I did not hear what...
Saying that 62 is dealing with a different point, and that paragraph 79 suggests that there was no decision taken, or you're saying there was no decision taken, and certainly not suggesting that a decision was taken for the reasons that you're now putting before the court. That summarises.
Well, my lady, the way in which it is put is that...
I mean, you refer at M to the appellant's deposits, and N, the exclusion of the appellant's deposits. So the implication is that there were deposits, and indeed in A you explain that what the appellants did was they received funds from their own depositors, which were placed in the parent banks as part and parcel of the conduct of that business.
Yes, my lord. So they were characterized as deposits.
Yeah.
They were characterized as deposits. However, what we are seeking to explain to your lordships is that the way in which the business was conducted, even though they are being referred to as deposits, having regards to how those funds were placed in the parent banks, the simple point we are making is that they continue to maintain their character. Their true character continued to be monies placed by foreign nationals in foreign currency, which were paid into the parent banks. And that is the context and the reason for the use of the word upstreams. So on the face of...
Could I ask you when this decision was taken and by whom, that was the true character of the relationship, and whether it was ever drawn to the attention of the applicants?
Well, as I said, my lords, the nature of the operation between the subsidiaries and the parents, which the central bank discovered, was revealed when it intervened, and at the start of the intervention, started to carry out its investigations. And it was at this stage when it found that the relationship between the parents and the subsidiaries were being conducted on the basis of what were called intercompany accounts.
But how could the deposits made by foreign customers of the subsidiary in a foreign currency, say US dollars, how could those maintain their character in the hands of the parent, where they would have to be in Anguillan currency?
Well, my lords, in fact, these deposits, as they're called, were not deposits in Anguillan currency. They were not in Eastern Caribbean currency. Mm-hmm. They were in US dollars, so that these payments were made into the subsidiaries.
Well, the parent couldn't lawfully carry on business.
That is so, my lords.
In US dollars.
And so, my lords, when the subsidiaries got these deposits from individuals, these funds in US currency were then placed with the parents. And what we mean when we say they maintain their character as offshore deposits was that this was all part and parcel of how the subsidiary banks carried on their offshore banking business. Ergo, we receive deposits from individuals who are non-resident in foreign currency, and then these are then paid into the parents who maintain as between themselves and the subsidiaries, intercompany accounts which would reflect payments in as well as payments out based on obligations of the subsidiaries which they fulfilled. That is how the banking business of the subsidiaries was conducted. And that is why we say that because that way of doing business was all part and parcel of the offshore banking business of the subsidiaries, that is why that aspect of their business did not fall to be regulated by the ECCB or did not fall within the ambit of the Banking Act, which only applied to banks conducting purely domestic banking business. And what
could I get your help then in relation to the following? As I understand it, you say that an investigation was carried out, presumably by the central bank. I don't know the date of it. As a result of that investigation, they formed a view that these deposits weren't correctly to be described as deposits for the purposes of the purchase agreements. Do I understand you correctly?
I crave your lordship's indulgence. Your lordship...
Lord Stevens is saying, is he understanding you correctly to say that the reason why these deposits, as the appellants described them, were excluded from the purchase agreement was because the central bank had found, after investigation, the matters you've described, and had concluded, in the light of our findings, that they were not deposits within the meaning of the legislation at all?
Well, my lords, what we would say is that that would have been a proper reason for the deposits to have been excluded. But in any event, and this is our central point,
I'm sorry, I have to press you for an answer.
Yeah.
Did that occur or did it not?
Did that occur or did it not?
I'm sorry, my lady, did what precisely occur?
Did this occur that the ECCB was brought in, it starts to carry out its investigations, it looks at the accounts of the parents and the subsidiary, and it sees that the money from the subsidiaries received from overseas customers is dealt with in the accounts of the parent as an intercompany account. And is it your case that on discovering that, the ECCB then concluded that because that was how it was dealt with in the accounts, that did not count as a deposit within the later meaning of the Act, which at that time didn't yet exist, but then came into existence?
Well, my lady, there had always been, and this again will be borne out in the context of the case to which I adverted, which was the case cited in relation to alternative remedy, that there was always a dispute as to the true nature and character of those funds which were being characterized as deposits, but which the ECCB's investigation showed, according to the books and records of the parents, were being treated as intercompany accounts and were not in fact being reported as deposits. That would be apparent in that case. However, in the context of the application for judicial review proceedings, that is not an issue which was specifically addressed at that stage. It was not specifically addressed. However, my lords, the point, the pivotal point at that stage, and which the third and fourth respondents reflect in their written case, is that having regard to the statutory regime and having regard to the fact that what was being characterized as deposits was all part and parcel of the carrying on of offshore banking business by the subsidiaries, by operation of law.
Well, could I ask?
They did not fall to
the question which my Lord Stevens put about 5 minutes ago,
yes,
and which was simply this: are you saying that the reason these deposits are excluded from protection is because the central bank investigated and found these matters to which you are referring, and concluded that therefore the deposits were not within the scope of the legislation?
Well, that would be one reason, my lord. But we also say...
Did it happen? Your answer 5 minutes ago was that it would have been one good reason. The question is, did it happen?
Well, the central bank did so find, my lords. And the central bank did so find. And that...
I mean, how many times... Could you give us a clear answer, please? Was this the reason for the decision that these deposits were not protected?
I would say yes, my lords. That would be one reason why...
You're saying it would be a reason. Was it the reason? I mean, are you putting forward, with the benefit of hindsight, a possible justification for what happened, or are you telling us what the reason actually was?
My lords, what I can say is this. That is what the central bank found. However, it did not posit that as a reason to the respondents in the context of their application for judicial review.
To the appellants.
To the appellants, I'm sorry.
Yes.
It did not posit that as a reason.
I suspect this is the first that those representing the appellants may have heard of this.
That was not posited as a reason, my lords, but what we are saying is that having regard to the statutory scheme and the way in which the business is conducted...
Sorry, I'm going to press you again. Not positing something is entirely different from... Not positing means not explaining to somebody, not passing on the information. But I want to know, was that the reason the decision was made to exclude these depositors?
A quiver indulgence. Quiver indulgence, my lord.
I'm sorry.
I crave indulgence, my lords. I just needed to consult for some specific instructions on that point.
Well, if you require specific instruction, it's almost the time we would adjourn in any event. So we could adjourn just now and resume at 2 o'clock. But I very much hope you will then be able to give us a clear explanation of whether or not these matters you're telling us about were the actual reason for the exclusion of these deposits from protection.
I will seek clear instructions on that, my lord.
Thank you very much, Mr. Dennis. In that case, we'll adjourn for the moment.